Will the House please come back to order? In accordance with the provisions of Uniform Rule 51, I turn the gavel over to the President of the Senate, the Honorable Gary Stevens.
Thank you, Mr. Speaker. Will this joint session of the Alaska State Legislature please come to order? Madam Majority Leader.
Mr. President, I move and ask unanimous consent that the roll call of the Senate be waived and all members shown as present.
Without objection, so ordered. Mr. Majority Leader. A brief at ease.
Yeah.
Please, Mr. Majority Leader.
Mr. President, I move and ask unanimous consent that the roll call be waived for the House and all members be shown as present.
Thank you. Without objection, so ordered. This joint session was called for the sole purpose of hearing the Chief Justice's annual State of the Judiciary. Will Senator Tobin and Representative Fields please escort the Chief Justice Carey into the chamber?
Ladies and gentlemen, the Chief Justice of the great state of Alaska, the Honorable Susan Carney.
Good morning, President Stevens and Speaker Edgman. It's good to see you all again. And good morning to all members of the 34th Legislature. Thank you all for the invitation to speak with you this morning about our branch of government and to update you on the current state of Alaska's judiciary. Before I move into my speech, I'd like to take a moment to thank the hundreds of Alaskans who work so hard for the court system every day. They range from front counter clerks in large communities like Anchorage to single justice magistrates in places like Yakutat and to the judges all over the state. We would not be able to continue to serve Alaskans without their dedication. Let me first introduce my fellow justices and other important members of our audience today. First is Justice Dario Borgeson. He came to Alaska from New England, as I did, to clerk for the Alaska Supreme Court, as I did, and he went to Fairbanks, also as I did. But he fled our extreme weather for the warmth of Anchorage. Among his many duties, he leads our very active Access to Justice Committee, along with Justice Jennifer Henderson. Justice Henderson also came to Alaska as a Supreme Court law clerk. She spent a year in Anchorage, and then she returned to Southern California, where she'd grown up. But she quickly realized she'd become an Alaskan, and she returned to Anchorage after that year away. She is co-leader of the Access to Justice Committee, along with Justice Borgeson. And she, in particular, has been very busy this year working with court staff, various committees, and judges throughout the state to move the oldest cases through the justice system and to prevent cases from lingering in the future. Next to Justice Henderson is Justice Jude Pate. Many of you have probably seen him as you go about your days here because he's the justice that lives here in Juneau. He moved to Juneau after he was appointed to the Supreme Court after 30 years in Sitka, where he held a variety of positions as an attorney, and he was also on the Superior Court bench there. The fifth member of the Supreme Court is Justice Amy Arabic. She is the other Fairbanks justice with me. And you may recall last year when we were here, she had been on the court for just about 2 weeks. She is now a veteran of a year plus 2 weeks. Like the rest of us, in addition to hearing appeals, Justice Aravic has a number of duties. Among hers is leading the Civil Rules Committee. We also have several vital members of the court system staff with us this morning. Stacy Mars is our administrative director. She and her staff are the ones that keep all 38 of our court locations open to the public. She's in the forefront nationally of efforts to increase access to justice, mostly because of our many court locations. Most aren't on the road system, and her efforts to bridge those distances places her first among her many colleagues throughout the country. And of course, you know Nancy Mead. She has been the court system's representative in Juneau for 15 years. She enjoys being with you here during session and providing you the court system's perspective on issues that may affect us. Nancy's always available to share information and to talk about anything related to the court system. Next to Nancy is Noah Klein, who is also familiar to you. He's our Associate General Counsel and is our administrative office's year-round presence in Juneau. He works closely with Nancy and is available to discuss the court system's budget or any other issues that affect us throughout the year. Finally, Suzanne DiPietro doesn't work for the court system. She's the executive director of the Alaska Judicial Council. The council is a constitutional creation entrusted with ensuring that Alaska state judges are selected based solely on their merit. Alaska's state judges are not appointed for life. All judges must retire at age 70, and between being appointed and retiring, judges' performance is evaluated periodically by the voters in retention elections and also by the Judicial Council. As Chief Justice, I'm the ex officio chair of the Judicial Council. In each of the meetings that the council has held in the year that I've been the chair, I have been really impressed with the dedication and the work that these volunteers put in. Last, but definitely not least in the front row, is my husband, Pete Braveman. And he's able to travel with me because he's retired. He spent decades serving Alaska's children and families throughout the state. Before I forget, I regret that we weren't able to host the breakfast that we usually host this morning, but the hotel where we usually have held it opened at the end of last week, maybe, so we just didn't have a place to arrange it. We really enjoyed the breakfast. It gives us a chance to meet you and talk less formally than this, and we really hope that we'll be able to do it next year. I promise you that we'll do our best. Now to the state of Alaska's judiciary. To begin with, I want to thank the media for once again providing me a topic to talk to you about. I say this partially in jest, but I'm also serious. It's not comfortable to have the press focus on a few extremely sad but also extremely unusual cases, but it's valuable for us. It's what a free press is supposed to do, to focus our attention where it is needed. The cases that the media has focused on last year and again this year remind us that the court system must remain committed to our mission, to justly resolve cases with integrity and with speed. I know that the cases with extreme delay are outliers compared to the vast majority of criminal cases and the time it takes to resolve them. but it's still heartbreaking to think of the anguish that victims suffer and the problems that delays cause to everybody involved in criminal cases. Before I dive into our current efforts to avoid extreme delays and resolve these oldest cases, I want to briefly recap some of our previous criminal justice discussion. During the pandemic, we held very few criminal jury trials, even though we were prepared to do that if the lawyers had asked us. Without the pressure of pending trials, lawyers at criminal justice agencies had less incentive to resolve the vast majority of cases, the 97% of criminal cases that never go to trial. Coupled with personnel shortages at both the agencies and the court system, the pandemic caused a backlog of criminal cases that grew and grew. Between January 2020 and January 2022, the number of pending criminal cases jumped from about 14,000 to 20,000. Such a huge jump in such a short time was unprecedented. Two Chief Justices before me have talked to you about our efforts to eliminate this backlog. Chief Justice Winfrey told you that we would clear the backlog. Chief Justice Mawson described how we're using trailing calendars and orders limiting continuances, and he praised the criminal justice agency's commitment to help us getting these cases cleared. And you, the legislature, helped alleviate the agency attorney shortages by providing raises to the lawyers employed both in the executive branch and the legislative branch. We have eliminated the pandemic backlog. There are now fewer than 11,000 open criminal cases. We have reached and have improved upon the January 2020 pre-pandemic level of 14,000 total pending criminal cases. We've addressed that backlog, but I told you last year, and I'll reiterate to you today, that our work isn't done. It's no secret that there are these outlier cases, and they have taken much longer than we want to resolve. But these cases are pending a lot longer than most. Median times to disposition, the time it takes from a case is filed till it's resolved, vary with the complexity of the case. So for Class C felonies, which are the largest category of felonies, the median time to disposition is less than 6 months. For unclassified felonies, such as the most serious sex crimes and murder cases, that median is a little over 3 years from case filing to the final resolution. That difference comes not only because of the difference in seriousness of the cases, but because of the complexity of the evidence involved. Audio and video recordings, DNA evidence. We're still working with all case types to shorten the time as much as possible. Shortly after I spoke to you last year, we took an important step in that direction. We issued an order, Supreme Court Order 2038, to prioritize resolving the very oldest criminal cases. Our order focused on resolving these very old cases, the ones that were filed before January 1, 2023, and were more than 2 years old at that time. Our order limited the number of continuances either side could request, and it limited the length of any continuance that was granted. Our order addressed continuance requests because judges are not the ones that delayed cases. Delays happen when an attorney, whether on the defense or prosecution side, asks for more time to prepare for a hearing or to file some kind of document, and the judge grants that request. Our order requires that any request for continuance has to be made on the record, which means in a written motion or in a hearing. And the order also requires that a judge must make the decision whether to grant or to deny the request on the record as well. As the year went on and courts became used to these requirements, momentum built. Some cases resolved because of our orders, and trial courts have carried that momentum forward. I applaud them for the hard work that they've put in. In the 4th Judicial District, the presiding judge just issued an order setting the cases that were filed before 2024 as a priority because they've cleared just about all of their pre-2023 cases. I live in Fairbanks in that district, but I can't take any credit for the hard work that the judges and the lawyers on both sides have put in to taking care of these very old cases. I will tell you, though, that when I dropped into the Martin Luther King Day free legal clinic to thank the volunteers that were there, one lawyer told me that his request for continuance had been denied because the judge said to him, "I do not want to deal with Sue Carney coming down to my office tomorrow." I'm in a different position than most previous Chief Justices when it comes to working with the judges. In my previous job, I worked with many of our current judges, either as coworkers, as opponents in court, and I even appeared in front of some of them. The relationships that I have and the fact that I spent so many years doing trials gives me a little more leeway to talk to them and to encourage them to continue to find ways to decrease the time it takes to get cases to trial or to resolve. But I know that I'm beginning to wear out my welcome. They are not as pleased to see me pop into their office. We're seeing results from all of these efforts. On January 1, 2023, there were 1,677 pending felonies more than 2 years old. That was nearly 1 out of every 4 pending felony cases. That number has dropped steadily, and this year, on January 1, 2026, we had fewer than 750 pending felonies over 2 years old. This is great progress, but we're still not satisfied, and we want that number to continue to drop. And we will work to continue to reduce the number of very old cases. To make sure this momentum continues to roll, my colleagues and I have just circulated a new continuance policy to all the judges. Like our previous Supreme Court order, the policy limits the number and the length of continuances. And it also includes examples that we hope will help a judge determine whether whoever's asking for the continuance really has good cause to get one. For example, a medical emergency will almost always be good cause to put off a case, but negotiations with the other side will just about never be good cause. We want this policy to provide clear guidance to judges when they're making those decisions. And we anticipate that the presiding judges in each of our 4 judicial districts will incorporate this policy into presiding judge order particular to whatever the circumstances of their area of the state are. Even though we are working very hard at this, the court system alone cannot make the criminal cases resolve more quickly. Others have a critical role in the criminal justice system. Many individuals and agencies are involved, from victims and witnesses to defendants, their lawyers, prosecutors, and we need sustained efforts from everyone involved. I recognize the difficulties that are facing the criminal justice agencies. They have finally been able to fill their many vacancies, but you've heard them describe how many of these recently hired lawyers are brand new. They're brand new not only to Alaska, but they're brand new to being lawyers. And that limits the type of case that they can handle. The cases that have extreme delays are almost always the most difficult kind of cases, unclassified or Class A felonies, and brand new lawyers are rarely equipped to handle those cases. Because we recognize their challenges, we continue to work with the prosecution and the defense agencies so that we can all keep cutting down the time it takes to move cases through the criminal justice system. These judges and the lawyers have very stressful and demanding jobs, and I really do commend them for the hard work that they're doing and the hard work that lays ahead. Up to this point, I've focused on criminal cases, and those cases are obviously very important. They impact public safety, and they are often high profile and newsworthy. But criminal cases accounted for 29% of all the cases in the superior courts in Alaska this past year. That number is just about tied with probate cases if you're looking at pieces of the pie. Probate is a very broad subject area. You probably know it includes estate issues, things like wills and trusts. But the biggest subset of probate cases is involuntary hospitalizations and commitment orders for those in mental health crises. These are difficult cases, and they often come up as emergencies, and they involve people's fundamental rights, like their freedom, their right to autonomy. Last year, Alaska courts handled almost 2,500 commitment cases, which may be a bigger number than you would have guessed. Probate cases also include guardianships and conservatorships when some vulnerable adult needs someone else to make decisions for them or to help with just getting through daily life. And as our population ages, this type of case is going to continue to grow. And those cases often go on for years and years because the protected person continues to need help. And you know that courts also handle domestic relations cases, family disputes. These were about 17% of all the cases in the Superior Court this past year. But if you ask any judge, I think they'll tell you they take more than 17% of the resources. These cases can be very challenging, especially if child custody is involved. And it's almost always one of the most important and consequential things that a family has ever gone through. Emotions run high, and the judge in these cases needs to be constantly aware of the changing interpersonal dynamics. The judge needs to constantly be aware to make sure that decisions are fair and well understood by the people involved. And 70% of family cases have one or both parties with no lawyer. This means that the judge needs to really explain carefully legal rules, requirements, expectations, and the decisions that the court is making to try to minimize any misunderstandings. They become a very large part of a Superior Court judge's daily caseload. The last type of case I'll mention is child in need of aid cases. They're about 10% of all the cases that the Superior Court handles, and that means there are about 1,900 of them each year. And every single one of those 1,900 cases is tragic for the kids and the family involved. In each case, the state has stepped in to protect the kids from neglect or abuse, and these families, like others in court cases, are going through one of the hardest things they've ever had to deal with. Emotions are high in these cases, too, and there are very strong but very opposing beliefs on all sides, and the stakes for the kids and the families are extremely high. I've described some of these case types, and they're just some of what the courts handle every day. Just to make clearer that although the criminal cases receive most of the attention, these other cases are also terribly important to the people that are involved in them. When people come to a courthouse, they are generally having their worst day ever. And they're going through very challenging and often life-changing circumstances. We work hard every day to provide not only fair and reasonable decisions, but to recognize the difficulties that Alaskans are having when they come into our courthouses, and to explain and to help them feel heard and feel that we understand them. Our training for judges and for all our staff is always to provide procedural fairness so that people can walk out of the courtroom and at least feel that the judge listened to them, treated them fairly, and understood what they were saying, even if they disagree with the decision the judge made. I'd like to turn now to a couple events that gave us cause to celebrate this year. First, I want to celebrate the rededication of the Utqiagvik Courthouse as the Sadie Brower Neakuk Courthouse. Sadie Neakuk was a trailblazer. She was a magistrate in Barrow before and after statehood. She regularly held court at her kitchen table and did it in Inupiaq when the people appearing in front of her didn't understand English. When she became a state court magistrate, she and Magistrate Nora Gwynn from Bethel insisted that they be able to hold court in the language that their community members understood. I used to spend many hours in the courthouse that's now the Sadie Brower Neakuk Courthouse, because I represented Alaskans from all over the North Slope. So I was thrilled to be able to join many local leaders, including Representative Fryer, the Neakuk family, and many young people from Utqiagvik at the dedication. And I want to thank the community of Utqiagvik and everyone who participated for hosting such a special event and allowing the court system to continue to have a dialogue with Alaskans and be really present in the community. Our second cause to celebrate came from the Conference of Chief Justices this summer. One of our civic outreach programs, The Color of Justice, received the prestigious Sandra Day O'Connor Award for the advancement of civics education from the National Center for State Courts. The program was originally focused on persuading students from all kinds of backgrounds to go to law school and eventually to become judges. Here in Alaska, the program has evolved into a broader one. We have court staff, judges, lawyers from the Bar Association, and other adults gather with high school students for 2 days of workshops, classes, and general mentorship opportunity aimed at enhancing their understanding of civics generally and the justice system. And at the same time, it encourages our youth to think about careers that are involved in the justice system in any way. Certainly lawyers and judges, but also police officers, social workers, accountants who will help the court keep track of bail money. The award committee was most impressed with how collaborative our Color of Justice program is. We work with the Alaska Native Justice Center, which handles much of the logistical part of setting up these programs, both in Anchorage and closer to here at Mount Edgecombe, high schools, law schools, and tribes. And we know that the program is reaching kids who would never otherwise have thought of a career in law. Magistrate Pam Hess, who sits in Nome, participated in the program when she was in high school. And then she went to law school at Gonzaga, one of the law schools that supports the program, and became a lawyer, and now she's a judge. She reports that she had never thought of being a lawyer before she participated in the Color of Justice program in high school. So I think we are correct to believe that mock trial, games like constitutional cranium, and sort of general civics education really can go a long way to encourage Alaskan youth who would never have thought of a career to think of it. I hope that the program continues to produce engaged citizens who may one day be part of this very conversation we're having, serving as legislators or maybe even the Chief Justice. In addition to civics education, the court system has a long history of collaborating with tribes across the state. Our rules have long recognized that tribal courts issue binding orders. For example, our Civil Rule 5.4 lays out how those orders can be registered, recognized, and then enforced, just like an order from a state court. And many of our child in need of aid cases involve Native children. That means that the Federal Indian Child Welfare Act controls portions of these cases and dictates how and when certain decisions need to be made. We've long had a relationship with the Alaska Native Justice Center that helps ensure that our judges receive ongoing and current information about the law's impact on Alaska Native families. And it also helps give judges and other professionals involved in the child welfare cases a more complete picture of the real-life effects these cases have on our communities. And as I mentioned to you last year, a couple of our therapeutic courts, one in Southeast at Sitka and one in Kenai, run as dual jurisdiction courts with tribal court judges as well as state court judges. That's my report on our efforts and our causes to celebrate. Now I must ask for your help to do things that we want to be able to do. In our first and frankly most unusual request of you is for a new judge in Palmer. You have heard, or maybe will hear, more about the details of this project. The Palmer Courthouse serves the entire Mat-Su area, which is the fastest growing region in the state. And unlike the rest of Alaska, the Mat-Su is projected to continue to grow significantly over the next few decades. The Superior Court judges in the Palmer Courthouse have a workload that reflects the growing population. They're the busiest in the state, and they have been the busiest each of the last 5 years. To ease their burden, we've cobbled together coverage for some of the most time-sensitive cases in Palmer by bringing in judges from Anchorage and from Valdez, and having retired judges serve as pro tem or temporary judges. This is mostly for criminal and child in need of aid cases. But that leaves all the other kinds of cases, the divorces, the custody, business matters, just waiting. We do not want to clear out all the oldest criminal cases, only to find a similarly problematic group of old civil cases causing our new crisis. To avoid this, we hope you will seriously consider our request for an additional Palmer Superior Court judge. We're renovating and reconfiguring existing space in the Palmer Courthouse, and we're leasing some basement space from the executive branch to accommodate this request for a new judge. We're doing as much as we can to meet the needs with our existing resources. On the capital side, our most urgent request is for continued funding of deferred maintenance. We know that deferred maintenance is a concern all across the state, but we have to provide safe and habitable spaces for the public and for our staff. We have a running list of projects that are necessary to keep our facilities habitable and to extend their useful lives as government buildings. Take, for example, the Snowden Administrative Building, which houses the majority of our administrative staff. That building used to be the Anchorage Times building, oh, so many years ago. And the building has a facade that's crumbling. It's barely keeping out the elements and the occasional vermin. On the facade, close to head height so that people passing by can see it, is a great big metal map of the state of Alaska. I'm sorry to tell you, Kodiak is no longer part of the state of Alaska. Fortunately, it didn't land on anybody going by. In all seriousness, we're doing what we can to keep our aging facilities operational and to prevent large-scale failures. But our buildings are aging, and some of the maintenance needs are becoming more and more urgent. We appreciate the funding you've given us in the past and your consideration of our current request. Once again, I want to thank you for your invitation and your attention, and I assure you that the court system remains committed to providing all Alaskans, wherever they live, access to our justice system. We're grateful for your continued support of our mission. Thank you. Thank you.
Thank you, Chief Justice. Madam Majority Leader Giesel.
Mr. President, I move that the joint session be adjourned.
Without objection, the joint session is adjourned.
The House will stand at ease.